Good afternoon and welcome to this year's Palme Prize ceremony. My name is Lisa Nåbo and I have the great honor of being one of the board members of the Olof Palme Memorial Fund, and I will also be your host today. You might remember me from last year when I tried to speak Norwegian because Utøya was that year's recipients. This year, the whole ceremony will be in English because of this year's recipients. And that is also the reason why no Danish person ever will win this reward. In the next hour, you will meet the two recipients of this year's Palme Prize. If you win, you receive honor, money, and this beautiful diploma. This year, we have made a small change to the diploma, and you have to be really close to see it. But right down here, in very, very small letters, it says that this award is given to you personally and can never, under any circumstances, be given to Donald Trump. Because what a year we've had, and it's only been a month. To be perfectly candid, det har varit skit. I'm sorry, but some things just needs to be said in Swedish. And I don't know about you guys, but I have felt both depressed and stressed over the state of the world. Some parts of the world more than others. But I am certain that today, together, during this ceremony, together we will feel hope again. Because this year's two recipients of the prize embody the memory and legacy of Olof Palme in the best ways. Their unwavering loyalty to justice, human dignity, and international law is really a shining light in these dark times. We will also have a great privilege of listening to one of Sweden's most beautiful voices. Lisa Nilsson is here and will bless us with her music. And another great voice, but maybe in a different way, Anna Sundström will lead today's panel discussion. But now, please welcome the chairman of the Olof Palme Memorial Fund, former Prime Minister, and my good friend, Stefan Löfven.
Dear friends, ladies and gentlemen, it is a pleasure and an honor welcoming you all to the ceremony for the awarding of the Olof Palme Memorial Fund Prize 2026. And we all, of course, want to extend a special, warm welcome to this year's two laureates, Navantham Pillai, or Navi Pillai, and John Dugard, two exceptional champions of human rights. Navi Pillai could not attend in person today because of her ongoing work for the International Court of Justice in The Hague. We will, though, meet her on the screen. John Dugard, though, is present. And, sir, listen to this welcome applause. We also welcome John Dugard's wife, Iche. You're more than welcome. Dear friends, in these times, human rights is challenged more than in a long time, meaning it is needed more than in a long time. Navi Pillay and John Dugard are South Africans, a country that became a strong symbol for the struggle for human rights during the long period of a cruel, hated political system, apartheid. So it is in a way also natural that we, in these difficult times, still let ourselves be inspired by an important victory for human rights more than 30 years ago, and be inspired by two role models that for many years have shown the importance of perseverance in the defense of human rights. One of the most important and powerful sources of inspiration in modern history is Nelson Mandela. And let me use one of his many inspiring quotes. Our common humanity transcends the oceans and all national boundaries. It binds us together to unite in a common cause against tyranny, to act together in defense of our very humanity. Let it never be asked of any one of us, what did we do when we knew that another was oppressed? Nelson Mandela's message is this: human rights are universal, and these rights must be protected by all of us in our close neighborhood, wherever we live. And that we should never get ourselves into a situation of indifference, never neglect, never stay passive, never be silent if fellow citizens are abused. Now, this thought of universal human rights is timeless. Although the concept of a universal right formulated in a common global declaration was realized after the Second World War, we know that these thoughts was also expressed already among philosophers in the ancient Greece, more than 2,000 years ago. Now, it was far from self-evident that concrete thoughts of human rights would develop. It was more like a slow start and gradual process, in the beginning actually aiming at liberating human beings from submissively only obeying orders from God or nature to individuals with the free individual right, the will, and the right to make their own decision. So over centuries and centuries, this process has been ongoing. And as we know, not until 1948, it was time for the world to come together and agree on how human rights should be expressed in a common document. Eleanor Roosevelt, a strong advocate for human rights and the only woman in the committee that wrote the draft, but she chaired the committee. She coordinated and guided 8 men in the work that resulted in an overwhelming majority of the United Nations General Assembly voting in favor of this declaration. And this declaration is exactly as relevant today, 78 years later. That shows both what a magnificent work the committee did, but also shows that human rights are timeless. It shows its paramount importance. After the declaration's preamble, the declaration takes us straight to the point in Article 1, stating that all human beings are born free and equal in dignity and rights. Then a total of 30 articles tells us what we have promised one another to respect and adhere to. The last article tells us what is not acceptable. And I quote, "Nothing in this declaration may be interpreted as implying for any state, group, or person any right to engage in any activity or to perform any act aimed at the destruction of any of the rights and freedoms set forth herein. Now, if the Declaration of Human Rights is the moral compass, the why, the world community also needs tools to ensure that we are walking in the direction of the compass needle. We need not least a legal handrail, and that is the how, the task for the jurisdiction, as in any field or sector of a society. And lastly, the why and the how must be complemented by who, because human rights need constantly to be defended, something that not just happens. We ourselves need to take responsibility. It requires devoted and skilled individuals. So we, the peoples, we are responsible for interpreting the whys in different situations, holding individuals accountable when breaching the rights, conducting complex legal processes. And for this, we are so grateful that fellow human beings have been devoting their whole lives in doing exactly that. Dear friends, to achieve a broad, deep, and strong defense of crucial human postures like the Universal Declaration of Human Rights, it is important to get to the core of understanding, explaining the basic substance in a way that makes it as clear as possible. And also here, Eleanor Roosevelt helped us on the way when she talked about human relations. And she said, "Tolerance ought only to be a preliminary step which allows us to get to know other people and which prevents us from setting up bars just because they may be of a different race or religion. The real value of any relationship is the fact that we learn to like people in spite of our differences." End of quote. What we hear in this quote is the innermost meaning of human rights, of human law, of humanity. Declarations remind us why we want to act in a certain way, and laws tell us how we should adhere to this and what should be the consequences if we don't. But the most fundamental ingredient in all this is the genuine understanding of true relationships. Dear friends, times are dire and difficult, but we know that through history mankind has learned that very few things we wish for happens just by itself. We must achieve it. Again, on behalf of the board of Olof Palme Memorial Fund, let me thank John Dugard and Navid Pillay for your lifelong commitment and contribution to the fundamental rights that demands equality between all human beings. Thank you for your tireless efforts in the spirit of Olof Palme. Thank you for listening.
Thank you, Stefan. It has finally come to the time when we will meet the recipients of this year's award. Here to guide us through it, we have the Vice Chairman of Olof Palme Memorial Fund. Please welcome the smart, fun, and handsome Joakim Palme.
Thank you, Lisa. I come to realize that there are many ways in which you can disappoint an audience. But dear Professor Dugard, you are awarded the 2026 Olof Palme Prize together with Navi Pillai, as you've heard, for your outstanding contribution to the defense of fundamental human rights. And we are all honored that you have not only accepted the prize, but also come here, traveled far, and joined us for the ceremony here in Stockholm today. First, I want to echo what Stefan said about the threats to international law and human rights. The reason is that states continue to commit crimes against humanity, including death, starvation, and the violation of human security and dignity. And we have seen that in Gaza, in Darfur, in Ukraine, as well as in other places, with all the brutality that comes with it. And our thinking in the Olof Palme Memorial Fund has been that those who act against these crimes deserve to be honored. And especially someone like Professor Duguid, with your lifelong commitment to international law. And I'll just bring out a few important examples. First, in South Africa, through research, activism, and litigation directed against the system of apartheid. Later in Palestine, as the UN Rapporteur on Human Rights. Also, a member of the UN International Law Commission, the ILC. And then recently, as a member of the team of international lawyers that drafted South Africa's 2023 submission to the International Court of Justice, ICJ, on alleged genocide against the state of Israel. All this in vigorous defense of international law as the cornerstone of our world order. John Duguid, please receive the 2026 Olof Palme Prize. And please join me in welcoming John Duguid up on stage. Professor Duguid, now the floor is yours. Yeah.
Joachim, Stefan, ladies and gentlemen, it is a great honor to be with you this afternoon to receive the Olof Palme Prize. Olof Palme, more than any other European leader, past or present, sought to assist the peoples of what we today call the Global South. The people of South Africa subjected to apartheid, and the Palestinians were his primary concern. In his last address to the Swedish Parliament, Olof Palme stressed the responsibility of Sweden to bring to an end the repulsive system of apartheid. At that time, I was in charge of a human rights body in South Africa that focused on litigation and advocacy against apartheid. We worked very closely with different diplomatic missions in South Africa in their struggle against apartheid. And it was very clear to us that the mission that was most engaged in the struggle against apartheid was the Swedish mission. And that was, I presume, in large part due to the instructions that the ambassador received from Olof Palme. Appropriately, Olof Palme was, in 2002, posthumously awarded the Order of the Companion of Oliver Tambo by South Africa for his struggle against apartheid and for a just world. Sadly, there's no European leader today who shares the same concerns of Olof Palme for the injustices inflicted upon the peoples of the global south, particularly the Palestinians. I'm pleased to share this prize with Navi Pillay, who I've known for many years. Navi Pillay was a student in my Roman law class in South Africa in the early 1960s, and since then we have worked together on the vexed question of Palestine. This afternoon I want to make a few remarks on the different ways in which the international community has dealt with the question of apartheid in South Africa and apartheid and genocide in Israel and Palestine. And I also want to look at the impact this difference has had upon international law. So let me begin at what is essentially the beginning for this purpose, 1948, which was a momentous year. On the 26th of May of that year, the National Party was elected as the government of South Africa on the platform of apartheid. On 14 May, Israel declared its independence. There was little rejoicing in South Africa over the election of the National Party, and there was certainly no rejoicing whatsoever in the capitals of the world. In contrast, in Israel and Western capitals, there was great rejoicing at the creation of the State of Israel. Israel was seen as a light unto the nations. This despite the fact that Israel was at that very time engaged in the ethnic cleansing of Palestinians in what is known as the Nakba, an exercise that today would be called genocide. The warm response to Israel's actions continues to this day in many parts of the world. There were, however, many, and there perhaps still are, similarities between apartheid in South Africa and in Israel. In particular, both engaged in brutal racial discrimination and apartheid and in political repression. For this, South Africa was punished. It became a pariah state subjected to sanctions of all kinds for its racist policies and practices. The General Assembly called upon states to break off diplomatic relations with South Africa, to boycott its goods, and to suspend cultural, educational, and sporting exchanges with South Africa. The Security Council imposed a mandatory arms embargo. Later, it called on states to suspend new investment in South Africa and to cease sporting and cultural relations with it. States responded very positively to these resolutions of the General Assembly and the Security Council. They took action against South Africa. They imposed very severe sanctions on South Africa in the economic field, cultural, sporting, diplomatic field. Of course, one cannot but remember that South Africa was expelled from the Olympic Games and for participating in other great sporting events, particularly in respect of rugby, South Africa's national game. And there's no doubt that the exclusion of South Africa from rugby competition made a great impact upon South African society. Initially, South Africa adopted a petulant attitude towards the world, pleading that apartheid was a purely domestic issue of no concern to the international community. Later, as South Africa lost the support of its Western allies, it adopted a more conciliatory tone, pleading that apartheid was a form of self-determination, granting independence to its tribal homelands, and spending generously on welfare, health, education, and industrialization in these territories. But the international community was not impressed at all. South Africa was instead denied the right to participate in the work of the UN General Assembly. Its grant of independence to its tribal homelands was simply rejected, and boycotts of all kinds grew and grew. Ultimately, apartheid came to an end. Many factors contributed to this ending of apartheid, which brought the apartheid regime to the negotiating table. But one factor was very clear, and that was that South Africa was out of step with the rest of the world. The violation of human rights of its indigenous population had resulted not only in sanctions, but in the contempt of South Africa for the rest of the world. South Africa's contribution to the development of international law during the apartheid years was enormous, but unintended. New rules of international law to promote human rights, decolonization, international humanitarian law evolved in the United Nations as a result of its opposition to apartheid. The International Court of Justice delivered judgments on South Africa's administration of Namibia, which developed the reach of human rights law and self-determination. So, ironically, South Africa succeeded, albeit completely perversely, in rejecting notions of racial equality, human rights, and self-determination into an international order that in 1945 had few developed rules on these subjects. So much for South Africa. Now let me turn to Israel and to compare the experience of South Africa with the world's attitude towards Israel. Israel has built a colonial empire in the territory it occupied in 1967 at a time when colonization is condemned as illegal by the international community. Israel practices a form of apartheid in the occupied Palestinian territory that far exceeds that of South Africa in its dehumanization, discrimination, and repression. It has deliberately killed, maimed, starved innocent civilians, stolen land, and destroyed homes, hospitals, mosques, and churches. Israel refuses to care for the welfare, health, and education of the occupied people as it is required by humanitarian law, by the Fourth Geneva Convention. Instead, this task is left to the international institutions and foreign donors. In short, Israel's administration of occupied Palestine has no redeeming features whatsoever. Now let me turn to the present situation in Gaza. The actions of Hamas in southern Israel on 7 October were both illegal and morally despicable. But seen in context, they were an inevitable consequence of decades of maltreatment of the people of Gaza. This was made clear by the UN Secretary General when he stated that Hamas's attack did not happen in a vacuum. It was the consequence of 56 years of suffocating occupation, violence, land seizures, displacement, destruction of homes, and absence of home. The Secretary-General concluded that the grievance of Palestinians did not justify the acts of 7 October, but they could not justify the collective punishment of the Palestinian people. Whether one calls Israel's actions genocide, as I do, or crimes against humanity, as clearly they are horrible, atrocious, beyond words. Over 71,000 Palestinians killed, of whom 80% are women and children. Over 170,000 Palestinians injured, including 6,000 amputations, mainly of children, deliberate starvation, destruction of homes, hospitals, and schools. How has the world responded to all this? Judged by resolutions in the General Assembly, there is strong support for Gaza. But this is the wrong way to judge the international response. Instead, one should ask what the response of Western states has been. First, Western states are the states most close to Israel politically, economically, and culturally. Secondly, they are the states that sell arms to Israel. Have these states condemned Israel's actions? Have they imposed economic sanctions on Israel, terminated cultural, diplomatic, educational, and sporting ties with Israel? Have they stopped selling arms to Israel? Have they endorsed or upheld decisions of international courts on the unlawfulness of Israel's actions? In other words, have Western states done all that is possible within the international system to compel Israel to change its ways? Sadly, the answer to these questions is a resounding no, at least in respect of Western states. They failed to use the remedies available to them. They have not imposed the sanctions that they imposed on apartheid South Africa for practicing a much milder form of illegality, a much milder form of apartheid. They are not prepared to describe Israel's actions as illegal, and they are not prepared publicly to respect the decisions of the International Criminal Court and the International Court of Justice. Western states are generally equivocal about whether they will arrest Netanyahu and Gallant as required by the Rome Statute of the ICC. Hungary has already violated this obligation. Although the International Court of Justice has yet to give a final decision on whether Israel has committed genocide in Gaza, most states have refused to recognize their obligation to take all measures within their power to prevent acts of genocide being committed by Israel. And of course, most states have refused to recognize that Israel is committing genocide, despite the fact that there is considerable evidence to support this conclusion before the decision of the International Court, before the final decision of the International Court of Justice. In 2024, July 2024, the International Court delivered an advisory opinion in which it held that Israel is in unlawful occupation of Palestine and obliged to withdraw from the territory, that Israel must cease the construction of settlements, stop practicing racial discrimination, and recognize the right of Palestinians to self-determination and the right of the Palestinian people to an independent state. Although this opinion is advisory, It is a correct statement of the law on the subject. How many Western states have endorsed this opinion? How many Western states have imposed sanctions, including an arms embargo on Israel for refusing to comply with the court's rulings? While international law was strengthened by the international response to apartheid in South Africa, it has been weakened and undermined by the failure of states, particularly Western states, to declare that South Africa is acting unlawfully and to sanction Israel for its unlawful actions. Of course, the position of European states is made difficult by the conduct of the most powerful state in the Western alliance. Today, we must accept that the United States administration is governed by deals, not by law, by the law of power and not the power of law. International law plays no part whatsoever in the decision-making of the Trump administration. In short, we live in a lawless world as far as relations with the United States are concerned. And of course, we've seen where this leads in respect of the United States invasion of Venezuela. And we know that no law can protect Greenland in the final resort from seizure by the United States. Western states are rightly alarmed by this whole situation. You will remember the words of Pastor Martin Niemöller, written in 1946, after 7 years in Nazi concentration camps. He wrote, "First they came for the communists, and I did not speak out because I was not a communist. Then they came for the socialists, and I did not speak out because I was not a socialist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak for me." The moral of this poem for the present situation, I believe, is clear. Failure to speak out and to take steps to enforce the law when it concerns the brutal treatment of an occupied people, the Palestinians, does have consequences. States that remain silent must not later complain when there is no law to protect them. Thank you.
Thank you so much for laying clear the foundations of international law and reminding us about the obligations that come with it. And please, since you're going to join the panel discussion quite soon, I would kindly ask you to take a seat here on stage.
Thank you.
Yeah.
Thank you very much for that warm ovation. Thank you so much.
I can take that. We now come to Act 2 of this part of the prize ceremony, when Navi Pillay is going to receive her diploma. But For that to happen, we're now going to watch a fresh recording of a brief ceremony that took place in the Peace Palace in The Hague, the location of the International Court of Justice, where, as you might have understood, Navi Pillay is this week serving as an ad hoc judge in the Gambia versus Myanmar case. The reason she couldn't come here in person. But if I'm not misinformed, she has joined the live streaming of this ceremony. So please help me welcome Judge Navi Pillay to Stockholm.
Happy to see you. So, Judge Pillay, it's fantastic that you have accepted the Olof Palme Prize for 2026, and I'm sure that you now know that we have awarded this to you from Duger for your outstanding contribution in defense of fundamental human rights, and that we thought that we should honor those who act against that and try to uphold international law, and specifically those like you and Professor Dugat, who do that in a systematic way and lay the foundations so that we can identify those who breach the laws and commit crime and put them to trial. So in retrospect also, you have such a long list of other contributions to human rights, and when I look at your work, it started in South Africa when you were a human rights lawyer,
yes,
and then became a Supreme Court judge. And on the international scene, you've been the president and judge of the International Criminal Tribunal of Rwanda,
yeah,
later judge in International Criminal Court, and then also president of the Independent UN Commission on the occupied territories of Palestine. That's a recent commitment that you took up, and now we are here because you're an ad hoc judge on the Gambia versus Myanmar case. But we're so happy that you took the time to receive this diploma symbolizing this year's Olof Palme Prize. So please receive this prize.
Thank you. It's a great honor. Thank you for your kind words also. Distinguished guests, members of the Olof Palme Foundation, and fellow advocates for peace and justice, good evening. I am deeply honored and excited to receive the Olof Palme Award from the Olof Palme Foundation, and it is a particular pleasure to receive the award jointly with my countryman, Professor John Dugard, whom we South Africans all hold in very high esteem for his lifelong contribution towards justice and advancing international law. For some of us, like John and I, it was a privilege to have known of Olof Palme and to have lived through his time, his lifetime. His untimely death at the hands of an assassin robbed us of a world leader who might, had he been alive, have unstintingly championed the rights of workers, the rights of the poor and the marginalized, as he did for us Black South Africans, as well as for Palestinians. It is important to know that his words reached us in the darkest years of apartheid, and that his words similarly inspired those struggling for rights across the world. It would be unfortunate if he is remembered solely for his unresolved murder. Today we gather at a time of great concern. The world is in upheaval. Multilateralism, which had stood as security against unbridled unilateral illegal actions, is bending towards the political and economic interests of great powers. The rule of law, international law, human rights, and democratic norms are under attack, and some say the United Nations itself is going through a crisis of legitimacy. The specter of nuclear weapons looms larger than it has in decades. The erosion of arms control treaties, the modernization of nuclear arsenals, and the rising tensions among nuclear-armed states threaten to undo decades of progress. Proliferation and nuclear saber-rattling are not relics of the past. They are present dangers, from the Korean Peninsula to Ukraine and the Middle East. So I'm deeply concerned that many governments today are actively working against the international rule of law. I believe that the international rule of law is one of humanity's greatest achievements. It is the idea that power is restrained by agreed rules, that borders do not excuse brutality, and that no state, no matter how wealthy, powerful, or militarily strong, is above the law. It is what turns raw power into responsibility and force into accountability. Without it, international relations collapse into a system where power dictates outcomes. The international rule of law protects civilians in war, preserves human rights and dignity, and provides predictability between states. It gives smaller and weaker nations a voice. It offers mechanisms such as treaties, courts, and institutions through which disputes can be resolved without violence. It is not perfect, but it is far better than the alternate, which is chaos governed by fear. Yet today, I see governments undermining the system from within. Some selectively follow international law when it suits their interests and ignore it when it does not. Others openly challenge the authority of international courts. They withdraw from treaties or refuse to comply with binding rulings. In doing so, they send a dangerous message that law is optional and accountability is negotiable. I see governments using national security as a shield for unlawful actions, eroding protections for civilians, for refugees, for workers and prisoners and others. I see disinformation campaigns designed to weaken trust in international institutions. I see vetoes, delays, and political pressure used not to uphold justice, but to prevent it. These unlawful actions do not merely weaken international law, they hollow it out. What troubles me most is the precedent it sets. When powerful states disregard the rules, they normalize lawlessness. They invite others to do the same, and when international law becomes selective, it ceases to be law at all. It becomes a tool of convenience. I want to be clear. Defending the international rule of law is not about opposing sovereignty. It is about recognizing that sovereignty comes with obligations. It is about understanding that long-term security and peace cannot be built on impunity, and that peace cannot survive without justice. It is to say that no nation, no leader has the right to hold humanity hostage. I believe the choice before us is stark. We can continue down a path where rules are bent, ignored, or rewritten by those with power, or we can recommit to a global order grounded in law, accountability, and shared humanity. We can reaffirm the equal dignity of all people. So without a doubt, in my mind, Olof Palme would have chosen the latter course. I choose the latter course because without the international rule of law, There is no protection for the vulnerable. There is no restraint on violence and no credible promise of peace. And once it is lost, rebuilding it may be more difficult than we imagine. Thank you.
Hello. We're going to sing a song that I wrote many years ago during a conflict, more of the internal, private type, with someone very dear to me. It was almost like a letter. I wrote it when I was in Brazil. And the question that is raised in the song is, do you have the courage to question your prejudice about me? Would you consider open your mind to maybe being wrong about me? And do I have that courage as well? That's a question that I find constantly actual in corresponding over internet nowadays. Because prejudice about each other is something that holds us back and stands in the way of reuniting. Hudlös, vågar du vara hudlös? Vågar du ha fel om mig? Och vågar jag leva? Man måste våga leva. Man måste våga ta det som en människa och ta emot en utsträckt hand. En hand du inte känner än. Jag är så trött på krigen. Det säger ingenting om oss. Brista, snart kan allting brista. Det sköra är så skört, det fula är så fult, det vackra aldrig vackrare. Under, ännu sker det under. Så låt oss bara ligga här en stund, en evighet, och ta emot en utsträckt hand. En hand du inte känner än. Jag är så trött på krigen. Det säger ingenting om oss. Bara bam bam, låt oss börja om igen. Bara bam bam, utan sköldar denna gång. Bara bam bam, det finns en väg ut. Bara bam bam bam. Ta emot en utsträckt hand. En hand du inte känner
är så trött på krigen. Säger ingenting om oss. Under, ännu sker det under. Så låt oss bara ligga här en stund. En evighet. Tack så mycket.
Thank you for that wonderful music, Lisa Nilsson and Mattias Torell. In this room, we have a lot of very interesting people. You should only read the resume of the people in the first couple of rows. Here we have former prime ministers, professors of international law, foreign ministers, a deputy secretary general of the United Nations. There is even a priest. And together, they have a collective age of 2 million years. Oh, no, just kidding. You look really young, I promise. But these people are a great bunch of human beings that I am constantly inspired by. They have achieved some big things and given my generation even bigger shoes to fill. They have proven that adversity can be fought and faced straight on, and that a better world is ours to build and create. And for that, we are very thankful. I will now leave the stage to a panel discussion, and here to lead us through it is one of the other young girls of the Memorial Fund. Please welcome Anna Sundström.
Thank you so much, Lisa. I'm very flattered. It's not that often nowadays that I'm called young, so I will really take it to my heart. I'm, of course, very honored to be moderating this conversation. Congratulations, John, to your award. But we will also be joined by 2 Swedish experts. So everyone, please help me to welcome up on stage Anne Ramberg, lawyer and former Secretary General of the Swedish Bar Association, and Mark Klamberg, professor in international law, Faculty of Law, Stockholm University. Please. I am so tired of the wars was something I took away from the song that Lisa Nilsson just gave us. And there is a way out. That gives us a bit of hope, and I think that maybe we will also find this way out together. International law is currently under unprecedented pressure. Both you, John, and also Navi, in your addresses here earlier, talked to this. Conflicts to democratic backsliding and challenges to the multilateral system. Commitments to international law increasingly being ignored. In his address to the Security Council, UN Secretary General Antonio Guterres earlier this week warned that around the world the rule of law is being replaced by the law of the jungle. We are very happy, of course, to have such a knowledgeable panel here to help us understand these challenges, maybe a little bit of the new rules of this jungle, but as mentioned, also how to find a way out of this situation that we now find ourselves in. So to start, I would like to ask you very short, in one sentence if possible, What do you see as the most urgent threat to international legal order? John, would you like to start?
Well, I think the Trump administration is a real threat to the very existence of international law. And in response to the question, what is to be done about it, the answer is clearly, it is time for states to see this clearly and to respond accordingly and to reinstate international law as the glue that binds nations together in the international field. Thank you.
Anne, what would you say? Trump administration being one threat.
That's one threat, of course, but from a more principled point of view, I think it is the hypocrisy and the double standards, application of the double standards, and the normalization of impunity for the power states, and that is, and also the selectivity, and I think that's a threat.
We'll come back a little bit to the impunity and what can be done. Mark, what would you say?
Well, it relates to what has already been said. I think the greatest challenges, they involve the idea that the world should be separated in spheres of influence dominated by a few great powers where they dominate over all other states. The idea that the erosion of respect for international norms, which are replaced by power politics, and what Professor Dugard already mentioned, selective compliance with the international law. That's the main threats as I see it.
I'm sure we will circle back to all three of these threats that you have identified, but let me first turn to you, John, because you have spent much of your career examining accountability, which was also raised by Anne here, for grave breaches of international law. So what would you say are today's mechanisms, such as the ICC or UN fact-finding missions, fit for purpose, or are we witnessing their gradual erosion?
I think the mechanisms that we have in force for securing international accountability have developed considerably greatly over the past 40 or 50 years, and there's absolutely nothing wrong with them. In fact, they are the best conceivable methods for securing accountability. One thinks of the International Criminal Court and the International Court of Justice and other regional courts and institutions. The problem is the refusal of states to implement these mechanisms. And that is the greatest problem, and I think that is what troubles us most at this stage.
And do you see any sort of positive trends or examples of jurisdictions and institutions that are successfully resisting this trend?
Well, the International Criminal Court has done something to secure accountability, but we see that the United States has responded by sanctioning judges and the prosecutor for taking action. And quite frankly, the response of states has been disappointing in their failure to come to the aid of the ICC. Fortunately, the International Court of Justice has not been directly attacked at this stage, but I think its time will also come.
And you talked to sort of the lack of accountability or the weakness of accountability, and you've been a long-standing advocate, of course, for rule of law, and the growing trend of governments dismissing or even politicizing international legal findings. What does this then mean for the trust for these institutions, which is also very closely connected to accountability?
It is, of course, a great problem, and we see it all around the world. We see it in Sweden as well. And I think everything starts on a national level, in a sense. If we can't stand up for the rule of law and at home, then you can't do it in an international way either, I think. But the problem is that when politicians and governments reject a judgment, it's not only that judgment. that is suffering. It is the whole idea, the ground that how do you say, the thing that law is above power, and that is, they are neglecting that when they criticize it from a political point of view. But that could also, I think, could be said that when the politicians and many governments in Europe today, they are criticizing the European Court of Human Rights. Britain is threatening to leave, and that's of course something, and this is very political and it's respectless, of course, and it is a problem for the Council of Europe.
At the same time, we've also seen how national courts have been used to sort of uphold also international law. We've had here in Sweden, not the least, also a few examples of this. How do you see the sort of the relation here, or the role for national courts to also uphold international law?
That is very important, and that's why I think that in Sweden, I think we have many cases in Sweden and in Germany. And the lawyers and the prosecutors and the courts have an important role to play here, I think.
The international law, of course, does not have a strong central executive power. We all know that this is maybe one of sort of the weakest, the weak point of the whole system of international law, lacking the executive power, which means that it's fundamentally based on the will of states then to follow, and here comes the sort of the politicization also of the court systems. Are there any reforms that you see, procedural or institutional, that could realistically strengthen accountability, as we've been talking about?
Well, international law to some extent has always been imperfect. We international lawyers, we have for a couple of decades had this phrase that almost all nations follow almost all principles and all obligations of international law almost all of the time. Now, the question is if we can still say that. I mean, if we're seeing what's happening, this phrase may be outdated. Now, with the examples of Professor Dugard and Judge Pillay, we obviously see that there alternatives to the organizations we have had and still have high hopes of. I'm thinking about the UN and the UN Security Council. I mean, your work in international courts is kind of an obvious example where you can still enforce or somehow get accountability. I would like to list 3 additional mechanisms or venues. So one, I think Anne Ramberg already mentioned, domestic enforcement of international law. We have to make it possible to use and apply international law in a domestic setting. Second, I would like to highlight the regional mechanism and compliance mechanism. I'm thinking about the European Union, African Union, Organization of American States, which have norms, which have mechanisms which we should use and reinforce if needed. And third, I would like to mention reciprocity as an accountability tool. Professor Dugard, you mentioned in your speech sanctions, which is an example of a tool of reciprocity. And it's one of the most enduring incentives for state compliance with international law. And states follow international law partly because they know if they don't follow international law, there will be a response from other states. It can relate to trade, it can relate to human rights. So I think it's important that states such as Sweden, together with other states, use this mechanism. It can be used even if the UN is not working as well as we would like it to work. So there are other mechanisms when, even in times such as this.
You mentioned, you had the metaphor in the end of your speech, sort of calling for the realization of maybe smaller and middle-sized countries, that if they do not sort of speak up, no one will also speak up for them. So it is the sort of the power of the strongest one, and then which would then rule. Do you see any tendencies, or how can we sort of awake then smaller and middle-sized countries to realize the importance for them to act on behalf of others?
Yes, I suppose one should mention the Hague group of states, today numbering some 30 states that issued a statement in 2024 and again in 2025 on the subject of respect for the rule of law and for international accountability, with special reference to the case of Gaza. This Hague group is led by South Africa and Colombia. And I think that's a small step in that direction. Of course, Mark Carney recently emphasized the important role of what he described as middle-sized states. Well, I suspect all states are middle-sized except for the United States and China. Even Russia, I suppose, by many standards, is a middle-sized state. And I think it's these states that should resist, in particular the United States. I think we all accept that Russia is a threat to the international legal order, but at least President Putin has indicated that he is acting in accordance with what he conceives to be international law. Whereas the Trump administration has just abandoned international law completely. And I think this is something that is so alarming that not only middle-sized states, but all states in the international community should have the courage to stand up to and oppose and reject. And I hope that in the next session of the General Assembly, we still have a year or a long time to go, that courage will develop.
It has, of course, also been the argument for Sweden being a long-standing advocate for the rule of law over the years. And I'd like to ask you, Mike, because you're one of the authors of the book Sverige och folkrätten, Sweden and International Law, where you look at Swedish efforts to develop international law and how international law should be applied to the Swedish legal system. Do you see any change in the Swedish approach to international law?
Well, I have two of my co-authors of the book in the audience, so I hope I can give it justice now.
We can continue the discussion.
I would like to highlight, certain parts of Swedish foreign policy, which we've had for several years. Maybe it's varying depending on which government is in power, but the feminist foreign policy, I would like to highlight foreign aid, not only humanitarian assistance, but also support to democracy movements, journalists, and thirdly, our engagement and commitment to environmental issues. All of those are kind of important trademarks of Swedish foreign policy, which is also relevant in an international law context. Now, you were asking for kind of specific examples, so I'll take three. So I think what was very important was when Sweden joined the European Union, we also incorporated the European Convention into Swedish law, which not only changed our relationship to Europe, but also how we rely upon law and rights within Sweden, which was very important. Anne Ramberg mentioned that we have had many trials in Sweden relating to war crimes, international crimes, and genocide. That's also a contribution that Sweden has made to develop and enforce international law. And thirdly, we have recently incorporated the Convention on the Rights of the Child into Swedish law. Now, we have politicians here, so I would like to raise a word of caution that it's one thing to incorporate these treaties into Swedish law. We also have to kind of we cannot put ourselves at rest. We also have to kind of look at specific instances and situations where we have to go even further and change Swedish law, adopt certain policies. If we're talking about children, there are kind of specific things we need to do there. How are they treated in school? Many children are recruited into criminality. How can we prevent that? So there's a lot of homework we need to do.
So Mike is also talking to, of course, the implementation of these conventions into Swedish law. And I mean, you mentioned also children's rights, and we have, of course, the Convention of Children's Rights being implemented also into Swedish law. So, and how would you sort of describe this implementation and the process of really adopting these and safeguarding human rights, and what role Sweden is playing also internationally to achieve this? I mean,
You didn't mention that question to
it's
me at
okay.
all.
It came now because
But,
of.
no, but the Convention of the Child is implemented in the same way as the European Convention, and that was very much debated, as you know, because it is not the normal way. But your question was how we.
No, how well do we do it, or what is sort of what lessons can be learned? What is it that we need to do better to make sure that these conventions are really applied?
I think we are a very good pupil. Normally, we take care of the conventions that I think so.
Yeah. Okay. But so human rights then protections often weaken during armed conflict. What role should independent legal institutions, civil society have in ensuring states upholding their obligations?
The civil society has a very important role to play. They can inform the public, and they have to inform the public. They can do strategic litigation, and they can establish a public opinion, I think is very important. They can also, now you asked about the legal.
Yeah, or the national bar associations, which could also be perceived as sort of a part of this pressure that needs to be put on governments.
I think there is in Cuba, I think 35 years or something. There is not a convention, but it's a paper about lawyers, and they do have a very important role to play in society. Actually, they have a duty to inform the public when the executive is taking too much power, or when the human rights are violated, for example. Also, not only the national bars, but also the international bars have an important role to play in terms of, I mean, solidarity and to help those bars in countries that suffer from, that are not democratic, for example. That's very, very important. But in order to do that, and in order to speak up, they have to be independent. And bars and lawyers are attacked today around the world in the same way as the press is, and so on. But that is a problem. But my firm belief is that civil society, NGOs, media, trade unions, bar associations have a very important role to play.
Not only do we see states sort of neglecting their obligations towards international law, but we can also see states increasingly invoking self-defense in ways that sort of stretch beyond traditional interpretations of international law. Has the definition of self-defense under Article 51 evolved beyond recognition, would you say, John?
Well, ever since the signing of the UN Charter, there have been debates about the interpretation of Article 51 of the UN Charter on the right of self-defense. And it has been interpreted in different ways, and there's no doubt that it has been interpreted by many states to allow its self-interest, national interest to prevail. But at the end of the day, I think we must accept that there's nothing wrong with Article 51 of the UN Charter or customary international law, which provides that an act of self-defense must be proportionate, which is the most important principle, perhaps. I think it's simply the failure of states to secure a fair interpretation of the right of self-defense. I hate to come back to the Middle East. I must confess that I've developed an obsession in the last few years with the failure of international law in respect of Gaza. It really surprises me that the international community has behaved so badly in respect of the protection of the people of Gaza. And I think the way in which Israel has been allowed to argue that it is acting in self-defense has been allowed by the international community, because most states tend to accept this. Speaks very badly not for international law, but for the political decision-making in independent states. And I think that's the problem. It's the level of political decision-making in national states that is responsible for the failures of international law. I don't think we should blame the Charter of the United Nations.
We can come back to sort of the lack of political will, because we're constantly coming back to this as a core element to the implementation and the respect of international law. But first, I'd like to turn to you, Mark, to ask, because, well, of course, the threats to international law are many, and the geopolitical changes that we see is mere one of all of these challenges. But we also have, of course, the climate change. We have also rapid technological change. And I know that you have also looked into a little bit of this and the implications of technological change for international law. So in conflicts where AI-driven targeting or mass surveillance is used, how should international humanitarian law be adapted to also tackle the technological changes that we are seeing?
Thank you. If I may zoom out a little bit, I mean, there's been two major conflicts who have been in our attention for very good reasons. The conflict between Russia and Ukraine, and the conflict in the Middle East. And in both of these conflicts, we can see parts of how future wars will be and how AI has been used and is used. It hasn't caused that much controversy in the conflict between Russia and Ukraine, but if you look at the conflict in Gaza and reporting from Israeli media and also in international media, you can see how AI has been used in what I would say a new way. Now, when we think about AI and robots, we think about robots or some kind of object, maybe a drone that is flying around, but that's not my major concern, or what I think is the greatest problem. A greater problem is how AI is used in decision-making. We could see reporting how AI is used to identify target persons and objects. And I think the interest in Israel to create political results, progress in their view, and kind of speed in the warfare has come at the expense of due diligence and care and respect for international law. From this reporting, we can see how many of the civilian casualties has been a result of, I would say, misuse of technology. This is a challenge because already in kind of modern warfare, I mean, modern military organizations involve hundreds of persons. And when we talk about responsibility, how can we identify and get responsibility from this kind of warfare where everybody can blame somebody else if somebody goes wrong? And then if we add AI into this type of warfare, how can we get responsibility? Now, your question was as I understand it, is existing law enough? And I think I would like to give a response in 3 parts. So first of all, we have to say that international humanitarian law applies also to these type of weapons and this type of technology. Second, there's always humans involved. So there's always a human who decides to use this kind of technology. And that person or those persons need to be accountable if something goes wrong. Thirdly, I lost the third one, but that's the two most important ones.
For the mingle.
Well, the third one. Now I got it. Your question was, do we need more law?
Exactly.
So I think it's unrealistic to think that we'll have a total ban on this type of warfare. I think maybe we can have some agreements. And one idea that I've tabled that we shouldn't use these type of weapons in populated areas, in cities where we have people. I think that's part of the reason why it hasn't caused so much controversy in the Russia-Ukraine war, because it has been used away from populated areas. And there it might work, but if you're using it in densely populated areas as Gaza, you will see massive damage and casualties to the civilian population, which is not acceptable.
So time flies. I will now, for sort of our final remarks, ask you both to try to address the issue of the political will, because we are circling back to that every time. I mean, we say that laws is maybe enough, but the willingness to apply is lacking. So both, what can be done to strengthen political will? And then also, if you would ask for, or if you see sort of one reform or one change that you would like to make to strengthen the international law, what would that be? Anne, do you want to go first?
Well, let me,
oh, sorry. Okay, John, please.
No, let me begin with your last question. The most important reform, I think, in my mind, it's to abolish the veto in the Security Council. We've seen the harm that this has caused in recent times, particularly by the manner in which the United States has exercised the veto in respect of Gaza. But to return to the first part of your question, I believe that international law is alive and well, and it's been developed into a very sophisticated system over the past decades. There's nothing wrong with international law. It's the political will to enforce international law that is completely lacking. And that's not a task for international lawyers. It's international opinion.
So I will ask the audience afterwards, because it was wrong of me to ask you as a professor of international law how to create the political will.
Well, I think it depends very much on international public opinion and the legislatures of national states and political decision-making of the leadership in these states. And that is really what I believe is lacking, that they do not act in accordance with the rules of international law, which are known to everyone today in large measure.
What's your comment?
I fully concur that I think the most important thing is to take away the veto, and also to you have to introduce some conflict of interest regulation at the same time. But that said, when it comes to politicians, maybe I repeat myself, but I think you see the development today where there's a very right-wing tendency all over the Western Europe and other Western countries. And it starts there, I think. International law is not living on its own. It is closely connected to what we do on a national level. And if we do not respect the rule of law and uphold human rights and protect human rights on a national level, you will never respect it on an international level. And politicians, I mean, it has to be a cost for not standing up for the law, even irrespective if it is national or international law, I think.
Mark.
Well, I have to apologize. I'm a little bit pessimistic when I look at what's happening in the world, so I will come with some more modest proposals. And I think we need to, when the great powers, and I'm thinking about the US has been very important in kind of creating the system we have today, which they, to a large extent, have abandoned. So we have to find workarounds, as I see it. When it comes to international trade, we have the World Trade Organization, which for many years had a very well-functioning dispute settlement mechanism, partly acting as a court. We need to find a way around that, and the EU with other states have already done that. They've created a kind of a new dispute settlement mechanism. That's what we need to do. When it comes to international criminal justice, we should continue to support the ICC, to have courts at the domestic level, and when it comes to human rights, to do our homework, what we're doing at home, but also to continuously support regional human rights, which we have in Europe, in Latin America, and also in Africa. So I think we need to find and kind of do workarounds at the moment.
Great, thank you so much. There are plenty of workarounds to be made. We've heard a clear message to say that the international law is there. It's for us, not the professors of international law and the lawyers, to make sure it's upheld. So I think it's a task for each one of us here in this room, and maybe also to ask ourselves if we do have the courage. And well, we all know, of course, that action also brings hope. So it's time to act. Thank you all so very much. Thank you. And with this, we've reached the final moments of this ceremony, and I would like to invite again up on stage for some more music, Lisa Nilsson. Welcome.
People who need people are the luckiest people in the world. We're children needing other children, and yet letting a grown-up pride hide all the need inside, acting more like children than children, and lovers. They are very special people. They're the luckiest people in the world, with one person, one very special person, a feeling deep in your soul says that you were half, but now you're whole. be a person who need people, people who need people, are the luckiest people in the world. And lovers, they are very special people. They are the luckiest people in the world, with one person, one very special person, a feeling deep in your soul says that you were half, but now you're whole. No more hunger and thirst, but first be a person who need people, people who need people, are the luckiest people in the
Tack så mycket. Thank you so much. This is my friend Mattias. We have known each other for a very long time, and we have been doing all sorts of music throughout like 3 decades now, I think. And recently I made another album, and it's one of the songs that I released was a song that many people thought were about them. I got messages from women who had escaped violent relations. I had letters from parents to children with different diagnoses. Everyone thought it was about them. And the thing is that it's about seeing each other, understanding each other, and accepting each other, and especially wishing for each and one of us to have a freedom of being yourself. To be free is the message of this song. And to me, it's about me and about you and about everyone. I was a rare child that escaped a lot into the forests and the void, and I still am. I usually, when people try to diminish what I say when I speak out, because I am one of those artists who actually do speak out, as the poem inspired us to do. In the artistic scene, I am one of those rare few, when it comes to Palestine especially. And
when people try to diminish what I do and who I am, they tell me that I'm childish and naive. Nowadays, I usually return that phrase and that rhetoric by thanking them very deeply and sincerely for one of the most beautiful compliments one can get. Hon dansar i silverregn. Hon tar aldrig raka vägen hem. Hon tycker om utkanten. Hon vandrar i cirklar. Hon talar i gåtor utan svar. Hon dansar i silverregn. Jag tror att hon är fri igen. Du ska alltid vara fri, min vän. Om de säger bli som vi, säg nej. Det är fel på dem, aldrig på dig. Fri igen, fri igen. Hon ser inte timmarna, kan sitta i fönstret hela dagen. Hon väntar på skymningen. Hon sjunger sin egen sång. Den blir lite bättre varje gång. Hon dansar i silverregn. Jag tror att hon är fri igen. Du ska alltid vara fri, min vän. Om de säger bli som vi, säg nej. Det är fel på dem, aldrig på dig. Fri igen, fri igen. Och jag vet, det kommer dagar med ett mörker inuti. Och du hittar inte ut. Men du ska veta, det går över. Du blir fri igen. Fri, min vän. Om de säger bli som vi, säg nej. För det är fel på dem, aldrig på dig. Fri igen. Fri, min vän. Om de säger bli som vi, säg nej. För det är fel på dem, aldrig på dig. Fri igen. Fri igen. Igen. Du är fri. Fri igen. La du da da du da. Ba du da da du da 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 da. La du
Thank you once more, Lisa and Matthias, for amazing music. Yes, the ceremony has almost come to its end, and I don't know about you, Stefan, but I've had a wonderful time. And before we all go out into the foyer for the best part of the evening, some wine, we will listen to some final remarks from Stefan. Take it away.
Take it away. So, dear friends, we have celebrated two champions of human rights, celebrated their lifelong dedication. It's so important issue. We have been reminded of the extremely dangerous situation that the world is in. But we have also been encouraged by the knowledge that there are so many people, so many good forces in Sweden, also around the world, that want things to be different. I believe that the speech that the Canadian Prime Minister Mark Carney held in Davos was such a moment when we saw, yes, there is another way, there is another path. There are so many good forces out there in the world. There is now, what we now need to do is to make sure that we gather all these good forces and strengthen ourselves the best we can. Let me just end by thanking everybody, of course. Lisa, isn't she fantastic? I want to thank also Joachim, the cooperation that we have, both in the board and but not least preparing for this. Thank you very much. Thank the whole board, of course, for its work. Also want to thank the panel, guided by Anna Sundström in a very good way, with John Dugard, Anne Ramberg, and Mark Klamberg. We, of course, want to thank Lisa Nilsson and Matthias Torell for fantastic, beautiful music. And last but definitely not least, the staff of the fund, and the staff is not big. It's Katarina Jonsson. She's doing a tremendous job preparing this, as you understand, this different perspectives of such a big event. But she's also been helped from some temporary staff. So warm thank you also, of course. Warm thank you to you for being here. It means a lot, of course, now and in the future. I hope you enjoyed this first part, and as Lisa said, now comes another part. We also hope you enjoy the mingling and enjoy a good drink, a good talk with friends. Thank you very much.